So, my lord, I'll go straight to the substantial question of law number 2. This is written like this. Whether the trial court committed an error of law by allowing the respondent herein to proceed and base her entire pleading on the document titled A Reply to a Counterclaim, despite the fact that there had been no counterclaim made and by penalizing the appellants herein for not making any reply to the said document. My lord, here...
One second. Yes. You are reading the substantial question?
Oh, yeah, my lord,
Yes,
yes.
please read it again.
Whether the trial court committed an error of law by allowing the respondent herein to proceed and base her entire pleading on the document titled A Reply to a Counterclaim, despite the fact that there had been no counterclaim made and by penalizing the appellants herein for not making any reply
You are
to the
reading the
said
number 2.
Number 2.
Yes.
I think I'm done with regard to that number 1.
Yes.
And my lord, here there was no objection submitted against to the said reply to counterclaim at the time of submission to the trial court. And
Sorry?
I mean the reply to counterclaim was submitted, my lord, before the trial court. Here, perusal of the order sheet of the trial court shows that the counterclaim was submitted. It is written like that. The original LCR shows that the counterclaim was submitted by the respondents. And in reply to that counterclaim, the reply to counterclaim was filed by the petitioner, which is at page 49, written as the reply by the petitioner to the counterclaim made by the respondents.
Because in reply to this counterclaim that was filed, the LSE was produced.
My lord.
Correct. That LSE was enclosed to this.
Yes, it is next in the in reply to the counterclaim also. The death certificate and all those things are enclosed.
If you go by the CPC, where is that provision for filing a reply to a counterclaim? And where is the counterclaim?
Counterclaim, my lord.
First of all, where is the counterclaim?
My lord, initially when
What is the counterclaim?
Counterclaim is the counterclaim made by generally made by the opposite party.
Opposite party, it makes a claim.
So
there has to be a counterclaim. Where is the counterclaim here? They have not even filed the WS. The Exhibit D is the only objection. There is no claim in Exhibit D.
My lord.
Correct. See, the pleadings are absolutely not in accordance with law, it appears.
Exactly, my lord.
Because you have claimed airship, they on advertisement gave a letter expressing their objection. Then it was tried like a regular suit. At that moment, there ought to have been some opportunity given to the opposite side to file their WS. That was also not given. Simply, on the contrary, the plaintiff side had filed a reply with the nomenclature reply to the counterclaim.
My lord.
That I don't understand how. Under what provision of the CPC that could have been done.
My lord, yes, in that regard, in my...
These procedural things I find is not in tune of the prescriptions contained in the CPC.
My lord, that is correct, my lord. That is correct. And with regard to the order sheet written in that before the trial court, in the order sheet, when the Exhibit D1 was filed by the opposite party, in the order sheet, it was written like counterclaim. The result of the order sheet shows that also. And by regarding that Exhibit D1 as a counterclaim, then in the next date, the time was spread for submission of the reply to the counterclaim. It was written in the order sheet like that. But as your lordship had already mentioned, specifically there was no specific prayer. Their only prayer in the Exhibit D1 is not to
That's not a
issue
counter
airship
claim.
certificate.
That is not, you can't say that to be a claim. They are not making any claim there. They are simply objecting from
Yes.
issuance of the airship certificate. That is their objection.
My lord, what I'm trying to say is that the trial court recorded that.
See, for some reason, if we find that this reply is not filed in accordance with law and the reply goes.
Yes,
Say,
yes,
assuming, suppose
Yes.
after we complete the hearing, we find that is not in accordance and we say this goes. Even then whether it affects affects you as regards the first part, because you have claimed the airship merely on the basis of the fact that your husband was the holder,
yes,
the
my
land
lord,
settlement.
my lord,
On
correct.
that basis, you are claiming.
Yes, my lord,
You have proved you are the legal heir.
my lord.
That you have shown of your husband.
Yes,
That you have shown.
yes, my
That
lord.
customary law is also there as far as you are concerned. To that part, because if we come to a finding that there is no dispute to the husband's title, then subsequent your succession is in accordance with law.
Exactly, my lord.
In that situation, even the second question goes against you. Perhaps the order of the appellate court and trial court will stand otherwise. Even if we remove because the reply counterclaim seems to be not.
Appropriate.
Where is the provision? And first of all, where is the counterclaim? There is no counterclaim.
Exactly, my lord.
So the question of, and where is the question of filing a reply? You show me the provision.
If yes, correct, my lord. That
And-
if there is no,
And by way of a reply, you have brought in an LSE purported to be in the name of your husband. They have not got the chance to rebut. They did not get the chance to rebut that LSE. That chance, natural justice is being violated. Isn't it? Because straight away thereafter the matter went to the evidence stage. Their rebuttal cannot be in the evidence.
exactly.
It has to be in the pleadings.
Yes, exactly, my lord.
The LSE was not produced by you at the first instance. It was produced by you later on. And to that, they did not get any reply opportunity also. Right.
Right, my lord. But at that time, my lord,
But
they,
even if we three agree to all this also, sitting in second appellate jurisdiction, what can be done? This is something also has to be seen. Because on the face of it, these things doesn't look proper to me. These are matters which concerns with the rights of the parties. Isn't it?
exactly,
So,
my lord.
at the time of deciding a heirship certificate, a proper application of mind, opportunities to parties must be given.
Exactly.
The court ought to have given them a chance to file a WS or to bring whatever they want to bring by way of written statement. That was not given. According to me, once an objection comes and thereafter it has to be tried as a regular suit, at that stage,
Exactly, my lord.
both sides should be given opportunities. Because when you apply for a heirship, you don't file a plaint. You don't plead everything, correct? You simply, I think it is just a simple form kind of an application, isn't it?
Exactly, my lord.
How can, that is not a plaint. Some procedures, I think it's time to be laid down.
Yes.
Because every time I hold court here, cases of such nature keeps coming, where I find sometimes there are cases where they don't, one will come after 10, 20 years and say, I had no knowledge. I have never received notice. And when we see, we find, yes, it was only published in the newspaper. The newspaper publication will not mean that one has seen. How can it be assumed? Can we assume that everybody will read the paper every day? So I think it's time, perhaps, some guidelines to be framed, issuing of notices, and once there is an objection, how it has to be tried, because then it becomes a regular suit. At that stage, no opportunities are being given.
But my lord, in that regard, yes, that is, your lordship is correct. But my lord, in this particular case, when the application was pending before the subordinate district council court, then the separation of judiciary comes into play, and after that, the case was transferred to the civil judge, junior division, and after that, the respondents also engaged a counsel. Even after engaging the council didn't take any steps for that.
For what?
For correction of the, for praying the court to submit the.
Mr. Joseph, before the break, you were saying something. You had an
No,
occasion to go
yes.
through the orders.
No, this statement my learned friend has made is not accurate, my lord. So, for the first time, after the Wakalat Nama was filed by all the appellants, for the first time, on, my lord, this is on 30/8/2011, the counsel for the appellants, my lord, had asked for filing of an additional WS, which was not allowed. This is the only time it was
That
allowed.
order is there?
Yes, that order is there. It was not allowed. It said not allowed, and then framing of issues. Now, this order, my lord, there's a Supreme Court judgment which says that this kind of orders
But
can be
Mr.
challenged in the
Joseph, huh? Can be challenged?
can be challenged after the judgment and order gets after judgment and orders.
Are you sure?
Yes, I think, my lord, there is. I can try and provide it, my lord, tomorrow also. And in the RFA, we have
But it is
raised this point.
unfortunate if such a prayer was made and not given.
Yeah, and we have challenged this in the RFA. We brought up this point in the RFA, and that is the reason why, my lord, it has become a substantial question also.
So you raised this point.
We raised this
before
point in the
appellate
RFA.
court.
Yes.
Then that is difficult. Because how can that not be allowed?
Yes.
Right? Violation of natural justice.
And this was after the separation. After the new
See,
after
separation, non-separation, principles of natural justice,
justice
has to be
comes in.
followed,
Yeah. Yes.
isn't it?
Exactly, my lord.
And after separation, obviously CPC has come in.
Yes.
Now, the second substantive question,
Because, my lord, this order.
I have my reservations as far as the respondent is concerned. I don't think there is any provision but we are now exercising second April. No, but here also, if I feel, I can always send it for retrial if I find that it has not been properly or the question which was supposed to be framed is not framed. I can frame the question and send the matter back for retrial, because the controversy that is involved in these matters seems to be the right title of the husband, number one.
My lord.
It appears,
My lord.
because the wife derives her title through her husband.
Exactly, my lord.
Now, if the husband's title is under cloud, then first and foremost that has to be seen. Now, here the limitation will come in, because otherwise it's 3 years from knowledge, I think, if I'm not correct. Now,
3 years from knowledge. Yes.
Correct?
Yes.
3 years from knowledge.
Yes, and we were prevented from, because of this case, because of the forum, we will have to apply for limited condonation, my lord, in that case.
No, if I put it here,
Yes. Yes.
please examine this issue, whether in this proceeding I can frame that issue.
Yes.
Because if I, after hearing you both, if I come to a finding that the title of the husband
In question.
is in question, and therefore an issue ought to have been framed, which was not framed, I can always reframe, I frame that particular issue and send the matter back for retrial. Isn't it?
Yes.
Now, whether I can do that, number one. Secondly, if any limitation or anything will come now, please clear these doubts also.
Yes.
Because at the end, we must try and put the controversy to rest.
Yes. Yes.
There is no point of unnecessarily
Yes.
dragging the matter if that controversy still remains open.
Yes.
Isn't it?
My lord, in my humble opinion, supposing if the matter is remanded back for retrial, and with regard to the question involving the legality of the process of mutation under the heirship certificate, in my humble opinion, will it be appropriate to consider by the trial court under heirship certificate? Questioning the legality of the process of mutation, my lord. Because in the
I'm sorry, I'm not being able to follow your submission.
my lord, the question that has to be decided by the trial court, if remanded back, is with regard to the legality of the process of mutation.
See, mutation.
Will it be
must have-
appropriate?
Mutation is not a declaration. Mutation doesn't declare your right title. Correct. Mutation
My lord.
is done on the basis of some document. Now that must have been the LSC.
What?
Now, how is the mutation done? On the basis of the land settlement certificate?
No, mutation was done, my lord, on the basis of some money lending, mortgage, some deeds, my lord. They are all there.
Correct. That's what I'm saying. And convenience has to be there.
Yes, but the conveyance are not transferred. They're not proper transfer of document. That's the reason why we are asking this court to go into this question.
No, now in that issue itself, one has to, entire thing will be open.
Yes.
Then you'll have to show how it has come, how you got it,
And my
the
lord,
right of acquiring the ownership.
that question your lordship had raised, my lord. Section 107. I'm not sure if this would be applicable, my lord, of CPC. This is within the general provisions relating to appeals.
Which one?
This is section 107 CPC, my lord. It says like this, my lord. Section 107 C. To frame issues and refer them for trial. This is power of the appellate court in general.
That is, you see, you come to order 41.
41, yes.
Order 41, you read 23
23, my lord.
and then 23A, because these are applicable in case of the same first appellate court
First appellate
powers are applicable to the court while exercising jurisdiction and the second appeal also.
Yes, yes, yes,
Right?
yes, yes.
It is provided. Now, if you see what can be done by the appellate court, just see that.
Appellate court, section 107, my lord.
Yes.
So the first thing is to determine a case finally. B, to remand a case. C, to frame issues and refer them for trial.
Which one? You're reading rule?
No, right now I'm reading section 107, my lord.
No, you come to order 41.
Order 41, rule 23, my lord.
Yes.
Where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case and may further direct what issue or issues shall be tried, and in the case so remanded, and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, with directions to readmit the suit under its original number in the register of civil suits, and proceed to determine the suit and the evidence, if any, recorded during the original trial shall, subject to all just exceptions, be evidence during the trial after remand.
Now 23A.
23. Where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed in appeal and a retrial is considered necessary, the appellate court shall have the same powers as it has under Rule 23.
Now 25.
where the court from whose decree the appeal is preferred has omitted to frame or try any issue or to determine any question of fact which appears to the appellate court essential to the right decision of the suit upon the merits, the appellate court may, if necessary, frame issues and refer the same for trial to the court from whose decree the appeal is preferred, and in such case shall direct such court to take the additional evidence required.
This is what I am proposing to do. I think under this, perhaps because it appears that an objection was taken
Yes.
and that was not ultimately, no issue was framed.
Yes.
There is no quarrel to the proposition which you argued that it has to be pleaded and all that. But you see that objection was taken, not that it was not there. Had it been absolutely not there, another thing. It is not the domain of the court to fish out disputes and make issues. This has to be raised. But here they did raise that question. But later on, somehow opportunities also seems to have not been given. Think over it. I am not going to dictate the judgment today. We will have it either tomorrow or day after. You both think over it, because as of now I feel this is a case which perhaps needs a retry. And such court shall proceed to try such issues and shall return the evidence to the appellate court together with its findings thereon and the reasons therefore. So I shall not dispose it. This case will be here, but will be sent back to the trial court on that limited issue, which I shall try. And on that issue, evidences will be taken, and thereafter the matter will be sent back to this court. I think that is how Rule 25 reads, correct?
Yes.
My lord, in that regard, what I'd like to submit is that the practice during the period of before the separation of judiciary, the courts are subordinate district council court, and when the heirship certificate is applied, it is written in a plain paper, somewhat like that, without any supporting documents. That is the
That's all
practice.
right. But you
And-
see, once the objection is given, but thereafter, at the time of framing issues, this issue should have been framed. Whether the husband is the rightful owner or not. It was assumed. His factum of ownership was assumed. The gift deed is not before this court. Though it is claimed that he got it gifted from his father. Right? That is not before this court. On the contrary, the trial court acted on an evidence which was brought by some reply to some counterclaim when there was no counterclaim. These things seems to be very illegally done in a hush-hush manner. Where is the provision of reply to counterclaim? And in this fact, where is the counterclaim? You both agree there was no counterclaim, isn't it? There cannot be a counterclaim. Where is the counterclaim?
In that regard, my lord, it seems that the trial court regarded that Exhibit D1 as a counterclaim.
How can it
That
be? How can the Exhibit D be regarded as a counterclaim? It is absolutely unreasonable if that kind of a view is taken. There cannot be. A claim has to be made. That is not a claim, they are objecting. Now, every time a person objects, can it be said it is a counterclaim? What is a counterclaim? Yes, counsel,
Yes.
what is a counterclaim?
Yes,
Please read.
It's a cross suit.
Yes.
across, so there has to be a specific claim. Yes.
Correct. When we make prayers, it's
Yes.
a counter.
It's a
It
plaint.
says counter because you are a defendant.
Yes.
Per contra, you are making a claim.
Yes.
But the claim has to be there,
Yes.
not the objection.
In that regard, my lord, if I may bring your lordship to the provision of the Mizoram Civil Courts Act, my lord.
Yes,
Here,
Mizoram
if
Civil.
Mizoram Civil Courts Act 2005, Section 21, my lord.
Then,
Section 21,
yes, please.
application of the court.
Yes, please.
Subject to the provisions contained in subsection 3 of section 1 of the Code of Civil Procedure 1908, the procedures prescribed in the court shall, save
are you reading
insofar
from?
as is otherwise
Where are you reading from? 21.
from 21, my lord.
Number 1,
Yes, my lord.
the procedure.
Subject to the
I'm
provision,
not getting subject. Where are you reading?
section 21, subsection 1.
Mizoram Civil Courts Act,
Courts Act, yes.
Courts Act 2005.
Yes, my lord.
Is there any amendment? Because I'm not getting. 21 reads like this. Application of the court.
Yes,
Number
that
one,
is the thing. That is what
the
I.
procedure prescribed in the court shall. It reads as. I'm not getting the subject. You said subject to. I'm not getting that.
My lord, here in my.
I'll see. I'll see.
My lord, it seems that this is the amended act.
Is it there
Uh,
in the
the,
compilation?
this is amended already. But what I'd like to mention is that, my lord, during the relevant period, this provision of section 21 reads like the provision of the CPCs to be followed in spirit.
See, that's why I said, in spirit also, principles of natural justice cannot be given a go by,
That is correct, my lord.
isn't it?
Yes.
Now, if an objection has been raised, then going by the decision that Mr. Joseph yesterday had cited, the apex court's decision, there then the court is bound to look into the predecessor in interest title as well. That decision is there. You have not distinguished that decision. Forget CPC, forget everything. The moment there is a question as regards the ownership of Mr. A, then how Mr. A got it to be also seen. Only if the ownership of Mr. A is proved, then the question of how, to whom it will go will come, isn't it?
Exactly.
Now here the wife is claiming it on the basis of her husband's LSC. But the other side is saying, how can it have been given without notice to us? Which they are right. So there is a dispute. because admittedly they are the legal heir of the original father.
In that regard, my lord,
You are saying there is a gift deed. The gift deed is not before this court. It's not on record.
not on record, my
Not
lord.
on
That is
record.
correct.
The moment they had brought this question, it was incumbent for you to prove it, bring that gift deed, and show it. In
But
the
my lord-
evidence, you have taken this plea that it was gifted by the father. Yes, sorry,
My lord-
you want to say something?
That regard, what I'd like to mention is that under this heirship certificate case, the issue is whether the wife is entitled to inherit the property of the husband. So the question with regard to the
I understand what you are trying to say, but in a given situation, you are correct. In a heirship case, the question is whether who will get it. The person claiming whether should get it, or if somebody objects to it, one will see between the two who will get it. But here is the case where they are objecting to the basic holder of that LSC, how he has been, how that has come to the husband. That they are clouding, they are saying, how could have been done without giving notice to us? This is there in their objection. And therefore they said, we do not give the heirship certificate to the wife.
exactly, my lord. But
Isn't
my lord,
it?
yes,
So the moment that comes, and you see, now the case is no longer a heirship certificate case, correct? It
Yes.
got converted into a regular suit.
yes,
Because
that
of
has
this
to be,
dispute.
yes, but that was not done. It has to be a regular suit.
No, but you see, it was done, but in a very different manner, which this court finds it very difficult to accept, because that is how the evidences have come. Ultimately, it was tried. The suit was tried,
Yes, correct, my lord.
isn't it? You have reduced evidences, exhibited documents. They have reduced evidences. That means the suit has proceeded.
Before that, my lord, it was seen that by the time they submit the objection, that infer that shows that they have the knowledge, and they have the knowledge, and after that, when the matter was referred to the court of civil judge, after the separation of judiciary, then they have their counsel. The respondents, the OPs have engaged their
Yes,
counsel.
that is what Mr. Joseph pointed out. They seek permission to file additional WA, which was rejected.
Supposing in that
See,
case,
forget all that procedures.
my lord,
If it comes before the court that there is one issue which is relevant for effective and proper adjudication of the list in hand, then this court under Order 27 of Rule 41 can always frame that issue and send it back to the trial court for further adjudication, to take fresh evidence and proceed and send it back. And while doing that, I am not interfering. I am not setting aside this judgment. This matter will remain here till the trial court, by giving chance to adduce evidence, decide that additional issue which I have framed and send the matter back. And then the entire matter again will be seen. This is how it has to be done, according to me.
my lord,
If at all that route has to be taken. But for that, of course, first I have to be satisfied that yes, the issue of the title of the husband was an essential issue which ought to have been framed, but not framed in the instant. Then I can send it back. Now, with all the discussions that we've been having in this matter since yesterday, it has come very apparent that this issue is not is undecided. It is only assumed on the basis of the LSE, which also has been brought on record in a very illegal manner. Not happy how it has been brought in, reply to some counterclaim when there was no counterclaim. It should not have been taken like that. both the parties ought to have been given opportunities to adduce their pleadings first, file their pleadings first, isn't it? Thereafter, issues should have been framed, and then evidences should have been adduced. That should have been the procedure.
Generally,
Just one
my
small
lord,
correction, my lord. I don't want to misguide the court, my lord.
Yes, sir.
The LSCs, my lord, were included in the original heirship application when they first approached the subordinate court. So it was enclosed there, and then we filed the written objection. But before we filed the written objection, my lord, we were not provided with that application. So the application is never provided to people who have seen the
Because
newspaper
you have
notice.
come by that advertisement.
Correct. So we only saw it from the reply to the counterclaim.
All right, all right. So that was part of the heirship application.
Original heirship, but yes, I don't want to be.
But that doesn't change anything, because once the other side raises an objection, then if we go by, let us see that decision which she had cited yesterday. I think that, because that is slightly on this point. Though till morning when I was reading this file today morning, I thought I was with you to an extent, to be fair. But now I'm finding, this issue ought to have been perhaps gone into.
my lord, in my humble opinion, generally when the heirship certificate is submitted before the trial court, the issue which is to be decided by the trial court is the entitlement of the applicant
Yes,
over that particular property.
You are right, but if they raise an objection, then how can the court not decide that then? Because they have raised an objection. Once they raise an objection, will it not be incumbent on the court below to first decide that issue or refer the matter to the civil court to decide? Let's read this, Mr. Joseph, paragraph 17, right?
Paragraph 17 it starts, but yes, paragraph 17 it starts, my lord. At the outset,
Mr. Liana, you may read it if you want, because you have to also deal with this case. It was cited by them.
My lord.
So you can read para 17.
I will provide it to him, my lord.
You don't have a copy?
He doesn't have a copy, my lord.
Just give your copy to him.
Yes.
You can read it loud
Para 17, my lord.
from para 17.
At the outset, let us examine the legal possession with regard to whom the burden of proof lies in a suit for declaration of title and possession. This court in Moranmar Basilius Catholicos versus Tucalan Paulo Avira observed that in a suit for declaration, if the plaintiffs are to succeed, they must do so on the strength of their own title. In Nagarpalika Jean versus Jagat Singh, this court held us under the onus to prove title to the property in question was on the plaintiff respondent. In a suit for ejectment based on title, it was incumbent on the part of the Court of Appeal first to record a finding on the claim of title to the suit land made on behalf of the plaintiff. The court is bound to inquire or investigate that question first before going into any other question that may arise in a suit. The legal possession, therefore, is clear that the plaintiff in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by using sufficient evidence to discharge the onus on it, irrespective of the question whether the defendants have proved their case or not. We are of the view that even if the title set up by the defendants is found against them,
In the absence,
in the absence of establishment of the plaintiff's own title, the plaintiff must be non-suited.
non-suited. We notice.
We notice that the trial court as well as the high court, rather than examining the question in depth as to whether the plaintiffs have succeeded in establishing their title on the scheduled suit land, went on to examine in depth the weakness of the defendant's title. The defendants relied on the entries in the GLR and their possession or repossession over the suit land to non-suit the plaintiffs. The court went on to examine the correctness and evidentiary value of the entries in the GLR in the context of the history and scope of the Cantonment Act 1924. the Cantonment Land Administration Rules 1925 and tried to establish that no reliance could be placed on the GLR. The question is not whether the GLR could be accepted or not. The question is whether the plaintiff could prove its title over the suit property in question. The entries in the GLR by themselves may not constitute title. But the question is whether the entries made in Exhibit A3 would confer title or not on the plaintiff.
Carry on, carry on.
This court in several judgments has held that the revenue records do not confer title. In Corporation of the City of Bangalore versus M. Papaya, this court held that it is firmly established that the revenue records are not documents of title, and the question of interpretation of a document not being a document of title is not a question of law. In Guru Amarjit Singh versus Ratan Chand, this court has held that that entries in the Jamabandi are not proof of title. Instead of HP versus Keshav Ram, this court held that an entry in the revenue papers by no stretch of imagination can form the basis for declaration of title in favor of the plaintiffs. The plaintiff has also maintained the stand that their predecessor interest was the patedar of the suit land. In a given case, the conferment of pata as such does not confer title. Reference may be made to the judgment of this court in Syndicate Bank versus Pepi IIC Limited and Vati Cherukuru Village
Come
Panchayat.
24.
So we are of the view that even if the entries in the Revenue Court of Rights carry evidentiary value, that itself would not confer any title on the plaintiff of the suit land in question. Exhibit 10.1 is Classer Register of 1347 Firstly, which, according to the trial court, speaks of the ownership of the plaintiff's vendor's property. We are of the view that these entries as such would not confer any title. Plaintiffs have to show, independent of those entries, that plaintiff's predecessors had title over the property in question, and it is that property which they have purchased. The only document that has been produced before the court was the registered family settlement and partition deed dated 11/12/1939 of their predecessor interest, wherein admittedly the suit land in question has not been mentioned.
So this decision of the apex court is very clear. If there is an objection to the predecessor's title, then the plaintiff has to prove it. So here they were raising a question as regards how it has been given without giving them notice to their brother, meaning thereby they are questioning the right title of the brother, the husband of the plaintiff. In that situation, the onus lies on the plaintiff to show that the father-in-law had gifted it to her husband. Where is the gift deed? Gift deed is not produced. Isn't it? If there is no witnesses who has said that we have seen so and so gifting it or so and so gift deed was signed in our presence, there is no evidence. And in matter of transfer, there has to be some deed. That is not there.
My lord.
In fact, that was not even an issue.
Yes, that was not an issue. If we
That
have
is-
to
see,
go to a
there are
broader
two ways.
issue,
There are two ways to look into it. One, this court can simply set aside the concurrent finding on this ground that absolutely without evidence, because if the concurrent findings are without evidence, it is perverse. And this court is entitled to reverse it if there are no evidence, right? Looks like there was no evidence. But what I feel is there was no evidence because this was not
pleaded.
this was not, it is pleaded, Mr. Kanchana, because they have said, taken that objection, may not be very elaborate,
My lord.
but that issue was not framed. You see, if that issue was framed, you would have got an opportunity to show that it was gifted to you by the father. And they would have also got a counter opportunity of showing, no, this is not done in that manner. Both parties would have got opportunities to adduce independent evidences and prove their plea. This was not done only, it was never taken an issue. That is why I am inclined to exercise my powers under Rule 27 of Order 41. Frame this issue and send it back so that this entire controversy is put to rest. What do you say, Mr. Joseph?
My lord, I think it's fair because they'll also have opportunity to
Both
produce the
parties
gift
will get
deeds and yes,
opportunity.
yes,
They will get an opportunity to show
yes,
if there is something, because otherwise I can always,
yes.
because till now, whatever has been argued from both sides, it appears there was absolutely no evidence to show that it was given to the husband. It is only presumed. It's inferred because of the LSC.
LSC.
You think over, when can we have it? Tomorrow? Day after tomorrow?
My lord, tomorrow also is fine as in yes, it's fine tomorrow.
Only thing, tomorrow, perhaps I might be in a DB with the Chief Justice. He
Yes,
will
that
be here
is the
tomorrow,
thing, my lord.
Because I'm told perhaps
Yes, yes, yes.
Friday also, my lord.
I think we'll keep it on Friday.
So Friday I have one matter before the DB also.
Then let's try tomorrow. Let me post it tomorrow. You see, because everything is only additional if you want to assist for assisting the court. If you want to show me something, you show me. Otherwise, I think you both have covered the factual aspect.
Yes, yes.
And I have already indicated my mind.
Yes.
Lordship, in that regard, one more thing what I'd like to submit is that even after engaging the counsel by the opposite parties, and when the chance of written statement submitting the written objection was closed, then if they are, if they are not feeling, if they want to, I mean, if the chance that particular order, if they want to challenge before that appellate court, they have the chance to challenge that particular order also. But that was not done, meaning that it was managed in a lackadaisical manner.
See, whatever that is, there is no, if this court comes to a finding that the ownership which otherwise was objected has not been gone into, then merely because they have not diligently proceeded with the case or not filed the written objections, we cannot say that the plaintiff has discharged the plaintiff's burden of proof, because then it was also the duty of the court to look into it. The court said, no, she is claiming it on the basis of her husband holding an LSC. And because of that, as per the customary law, the wife, she has to be allowed to stay and accordingly proceeded, rendered his judgment. Correct?
Yes.
But how the husband got it, that part, the court didn't go into, despite they have raised that in that Exhibit D. And you are only saying that strictly the written statements, everything is not filed in these cases. I'm not getting into all that. I'm keeping it very clear that this issue, even reading from Exhibit D, appears that they have objected to the title of the husband. Since there has been some sort of an objection, it was incumbent and an imperative of the trial court to look into this aspect. And in this, I'm supported by this decision of the apex court, which they are relying. You understand?
My lord, yes,
So,
I'm getting your point.
therefore, I want to say, I'll frame it and you look into it. You both will get your opportunities. And I'll fix a time within which they will report us back.
But in the meantime, my lord, that substantial question of law number 1 deals with the absence of pleading. So
See,
can we go by, will there be any contradicting view?
While
With regard
dealing
to-
with the substantial question of law in second appellate court, if the court comes to a finding that there are other issues or connected issues which are also important, this court can always do it,
My lord,
isn't it?
my lord,
Order 27.
my lord.
Because in connection only we are doing it. Because once the report comes, everything will be in front of the court. Think over. I don't want to do something which may not be correct, so you can assist the court. It's also an academic exercise.
In my humble opinion, my lord, before the trial court, the counsel representing the opposite party are handling the case in a very poor manner. The
will
level,
not go into that.
the level of practice is also
No point in
not
shifting
satisfactory.
blame.
No, I'm not blaming.
No point. Because the issue, I'm now very strongly believing that this issue was taken up, the dispute did rise, therefore an issue ought to have been framed and decided.
What I'm trying to say is that, my lord, if they are aggrieved with the manner in which the trial court is handling the case, by passing the impugn order, by closing the chance like that, they have to challenge that order at the right time also, before the appellate
Even
court.
if they don't-
That they have not done, and they,
Even if they don't do it, now when everything is before this court and this court finds, this court merely because they have not done anything doesn't mean that this court will confirm the order. When the court finds that the trial court did not go into an issue which ought to have been gone into, to put the entire controversy into rest. Because what is the duty of the trial court? What is the duty of the trial court?
To establish
To-
the facts,
to-
to bring everything, all the issues.
Correct. To put all the issues at rest.
Yes.
This is why a litigant comes to the court. A litigant comes before the court so as to the entire issue is decided and put to rest. Not in a half-heartedly fashion.
Yes.
Justice has to be done properly. Not for the sake of doing it. Tomorrow?
And we'll give the translation also of the
Yes.
application.
Please join translation.
Joint translation.
my lord,
Heard in part, list again. Tomorrow date. Mr. Joseph?
Yes, my
See
lord.
if you can get me something. 21-27.
I will do that, my lord.
The manner in which even you can assist. The
My lord.
manner in
My
which
lord. That I'll do,
it can be sent
my lord.
on that.